where we left off. Thank you, Judge. May it please the court. Judge, motion 29 is a motion for funds for an investigator. It's a defense motion. We have asked for some funding for an assistance of an investigator. I believe the state is objecting to this. Just as way of background, in this case, we have received a witness list so far. I'm sure that will be supplemented at some point in time, but the witness list as of August 15th, 2018 includes 52 people. 17 of those have missing date of births, 16 of those have missing phone numbers. On that witness list, there are 7 GBI investigators or agents. There are 8 police or sheriff's office officials. So those are all investigators that are working with the state and are available to the state and part of their resources. I do not know if the DA has an investigator, but I assume that they do have an investigator or they rely on law enforcement. I assume they did, and I also assume that they have victim witness advocates that assist them in getting witnesses to and from court, issuing subpoenas, bringing them to court, coordinating during a trial. When we are litigating the case and the state's litigating the case, they use investigators and victim witness folks to bring witnesses in, to call witnesses and say, we're almost done with this witness, we need you in 10 minutes, things like that. That's something that we don't have the ability to do when we're trying the case. GCIC, another example. The state can run criminal histories on witnesses in their office. We don't have that ability. We've got to have an investigator run those GCICs for us through the state agency. It takes several weeks. We've got to have date of births to run those. So we've got to have an investigator who can find the date of births for all of these 17 witnesses that don't have date of births that are on the state's list. 16 of them don't have phone numbers, so we need to contact them and need to find their phone numbers. We've asked the state, I understand that they don't have those in their possession, so we need someone to get that information for us. Another issue is if I am forced, or Mr. Merchant is forced to interview witnesses, any of these witnesses on the list, or any other witnesses that come about, and then that witness takes the stand and says something different than what they told us, we become witnesses in the case, which puts us in a very unfortunate position of being an advocate and a witness, which is prohibited by the bar rules. And that puts us in an ethical quandary at that point in time what to do. So the recommended practice is always have an investigator present for any witness interviews, or have the investigator do those interviews. As we stated in our motion, this is a very voluminous case. The state will have law enforcement available to deal with any last-minute witnesses. If we were hit with a last-minute witness, we would be forced to ask for a continuance without an investigator because we would have to do all that work on our own. I always have an investigator on any serious felony. I always have an investigator when there is a large number of witnesses or a large case file. And another issue is that the state regularly in closing arguments, in my experience, and I don't have any particular experience in this case with these players, but across the state, there's a lot of arguments in closing that, oh, well, the defense has the same subpoena power as the state does. So anytime we argue that, well, the state didn't bring this witness, or the state didn't provide this evidence, or the state failed to explain this, anytime we argue that as a burden of proof issue, the state comes back and argues in closing, the defense has the same subpoena power that the state has. But what is failed to argue is that we only have subpoena power if we have an address, if we have a location, and we can personally serve that witness, which is what we need an investigator for. We also need to find the witness. So if we can't find the witness, we can't subpoena them. If we don't know about a witness or we don't know where they are, we cannot have them subpoenaed. So without an investigator, our subpoena power is essentially useless because I'm issuing a subpoena that I'm not serving personally. I don't have the power to compel them if I don't get them under personal service. So we want to avoid that problem where there's an argument later made to the jury that, well, I know that the defense is arguing that we haven't proven this or we haven't brought this evidence. Well, they have the same subpoena power. We want to make sure that we actually do have that same subpoena power and that it's just an even playing field. I'm surprised the state is objecting to this. We are only asking for one person, for one investigator. compared to the numerous ones that are at the state's hands, and we just want an even playing field, Judge. We want an investigator to use for the trial so that we would have an even playing field.
It's unusual, Ms. Merchant, that attorneys in private practice ask the court for resources in this regard. Since the public defender's system we now operate under came into existence through state legislation, help me understand why, what your argument is y'all are in private practice, but we still need public funds
right.
to represent our client.
Yes, definitely, Judge. And one of the things that we feel strongly about is we take at least one pro bono case a year, and we are willing to devote our time and our resources. We pay for our own expenses. We pay our own room and board. We're paying for our paralegal to be here to assist us because she's on staff. If we had an investigator on staff, it would be a different story. But we do not have an investigator on staff. So we're not asking for resources outside of our law office. We're willing to donate those in our time. And we're actually, we believe, doing a service and saving the county a lot of money by us volunteering our time, because you don't have to pay for a public defender to add this to their case count. And
of course, since the advent of that program, the state pays the cost of the public defender, not the county.
well, I believe the county supplements. I believe that there's a county supplement.
I'm sure there can be for every
Right.
circuit is different.
Right. I believe that there are there's county supplements and there's state funding, and so those funding issues are present all the time, whether or not we are the public defender or whether or not we are taking the case pro bono. It doesn't affect his ability to get a fair trial. He should still be able to get a fair trial and have the resources that he needs in order to defend his case. And the fact that we're willing to donate our time free of charge does not affect that, and doesn't affect his ability to hire or not hire an investigator. He still is indigent. That nothing has changed by the fact that we have agreed to take the case pro bono. I regularly have to make requests like this in cases that we do handle pro bono, and who pays for it, that's an issue that depends jurisdiction by jurisdiction. If the court was
asking me to find that there's a need for it in this case.
Yes, Judge, we're asking you to find that there's a need, and we're asking you for you to authorize funds for us to hire an investigator.
Funds from the state or funds from the local?
Where it comes from is not something that we even feel like we have an argument in. But I'm happy to assist in that manner. If the court was inclined, I don't know the resources of the public defender. I mean, we can use a public defender. I don't know how that would work, but if they have an investigator that they can supply to us, then that's fine. That may or may not be feasible depending on if the case is moved with the change of venue. But what we need is we need to know that we're going to be able to have an investigator, particularly at this point, run all of this stuff down so that we can start interviewing these witnesses and have someone present for all of these interviews.
Thank you, Mr. Merchant.
Thank you.
Mr. Bennett, is this yours?
Yes, Your Honor.
Should be open. Okay. Yeah, copy of the act. Thank you. Yes.
That's the Georgia Indigent Defense Act of 2003, I believe. Yeah. I think I misstated in.
This is Title 17, Chapter 12, Legal Defense for Indigents. Is what I referred to.
In response to one of your questions, Ms. Marchant, you asked who are you asking me to pay for? If you read their motion as they filed, they're asking the court to require Irwin County to provide defense counsel with adequate funds to hire an investigator. So they're asking the county to do it. Since 2003, Irwin County has been out of the indigent defense business. The state has decided as a matter of public policy for the state that they're going to provide indigent defense. There's some exceptions to that. Single county circuits and some of the metro counties were allowed to opt out, such as Cobb County, Gwinnett County. I think there's some others who are not part of that system. But otherwise, indigent defense is on the state and not on the counties. By history, in this case, Mr. Duke was arrested in February of 2017. He applied for indigent defense counsel, which was provided to him. And in fact, the public defender's office has assigned or had assigned 3 lawyers to defend Mr. Duke. They have investigators. They have all those resources that the state provides. The fact that Mr. and Ms. Merchant want to volunteer to get in this case, they need to take into consideration that they can do it. because the state has provided a manner to do it. Now, if they think they're entitled to funds and it should be paid by the indigent defense system, they need to talk to the people in Atlanta, because they're the ones that are responsible. They cite 2 or 3 cases in their motion.
Akey, of course.
Yeah, Akey versus Oklahoma, Thornton's a Cobb County case, Lindsay, and Dingler. Dingler is the only case decided after the act was passed. Dingler is a Gwinnett County case. In that case, I think they were asking for psychiatric help, and
What happened?
they appointed someone, I believe. But Dingler, Gwinnett County is not a part of that system. Gwinnett County opted out of that system, and they provide their own indigent defense. And I have seen no cases where the local counties have been required to supplement. Now, they have a budget and they pay that budget, but they won't cost them any more money for the public defender's office to defend Ryan Duke than it would anybody else. It wouldn't cost Marion County any more money. And we think that it's the intent of the legislature that is borne by the state, and that's a matter they should take up with the state. It's not appropriate to require the citizens of Irwin County to pay those monies simply because they want to get in this case. We object.
Is your position then, irrespective of whether he's indigent or not, that is Mr. Duke, that he's required to make a choice between going with the public defender system the state has provided versus somebody who wants to donate their time who may or may not have adequate resources at their private practice to do what the public defenders are? Is that what you're saying?
Yeah, I think that's correct.
Agency doesn't matter.
I think that's correct. I can remember the days when lawyers were appointed individually to represent clients, and you'd have clients, well, I don't want Paul Bowden to represent me. I want Emory Walters to represent me. You don't get to make that choice. Once you ask for court-appointed counsel, you get the counsel that's been provided, in this case, through the Georgia Indigent Defense Act, 2003.
As a matter of constitutionality, do you believe the court retains the authority set forth in Akey versus Oklahoma and those matters to appoint or give proceeds to pro bono attorneys that are representing?
You may have the ability to order the state to do it. We've been back and forth with this issue in the death penalty case in Irwin County, in Tift County, multiple hearings about paying for, in that case, conflicts counsel.
Of course, in capital cases, though, there's some statutes about sharing between the county and the state in death penalty cases. I can't find any like statute as it relates to non-death penalty cases.
But I think it's incumbent upon the state to do it and not Irwin County.
Thank you. All right, you get the last segment first. Do you have anything for?
Judge, just for clarification, so I know what I'm arguing. So the state doesn't oppose us having an investigator. It's just a question of where the funds are coming from?
As your motion, your motion says require Irwin County to provide defense counsel with adequate funds to hire an investigator. I understand the state's position is Irwin County is not required to do that. Correct.
Judge, our motion says that we request that the court enter an order appointing an investigator to assist the defense both prior to and during trial, or in the alternative, require Irwin County to provide defense counsel with funds to hire an investigator. So we're asking for the alternative. So I guess the first question is if the state opposes us having an investigator appointed. And then I just want to make sure I focus my argument, whether or not they're objecting to us having an investigator appointed, and it's just an issue of who pays for it, or if they're objecting to us having an investigator appointed at all.
I think it's the former. Is that correct, Mr. Bowden?
I think they can make a showing if it satisfies the courts in your discretion whether or not they make a proper showing for the need. But my objection is to being paid by Irwin County.
Okay, so there's no objection to us having an investigator. It's just whether Irwin County pays for it or the state, whoever pays for it.
That's what I understand. Is that correct, Mr. Bowden?
Yes. There's a Supreme Court case, Georgia Supreme Court case that says, the need of investigators basically on the same footing as a psychiatric witness or something like other expert witness, that it can be on the same footing as that. If a proper showing is made, the court has discretion to make that determination. All right.
Judge, so I'm assuming that you've demonstrated the need based on all that, but just to be clear.
Unless the state wants you to present evidence in that regard, what you told me in your, don't believe the evidence is necessary for that? Yeah, what you told me, I understand your need.
Thank you, Judge.
Yeah, go ahead.
Judge, we were just arguing, this is akin to, a translator. If there was a translator, the court pays for a translator if there's private counsel. If there's transcripts, we pay for the court reporter to be here. Whether the client is indigent or not, if I had been paid in this case, the court reporter would still be paid for, and I don't know where that money comes from. I've never known where that money comes from. That's not part of our job is to represent Mr. Duke. And when we make the appropriate showing and we ask for the funds, I'm not sure where that comes from or how it's appropriated. But it's just like if we were asking for a translator, or if he did not speak English or needed a sign language translator, or needed some accommodations with hearing or visual or things like that. I assume it's the county that provides that, but what we are showing is the need for the investigator, and we're happy to work with whoever it is to figure out if it's appointed, if it's a public defender appointed investigator, or if it's someone that we bring in. We are willing to work with any investigator that will satisfy the financial needs. But we do not believe that finances should dictate whether or not he gets a fair trial, and who pays for it should dictate whether or not he gets a fair trial. Thank you.
Okay, thank you. All right, what's next? I'll get you an order on that as soon as within 48 hours of us completing these. What's next? Mr. Murphy, is it your turn?
Yes, Judge.
This is about court reading the indictment.
Yes, Judge.
This is number 32.
Yes, Judge. Motion 32. May it please the court. Judge, this is a fairness motion. To be frank with you, you have the discretion to read the indictment or not read the indictment. We brought this motion to the court's attention and asking you to not read the indictment to the jury for one very important reason. It gives credence and credibility to the charges that is different than that may be given by the state in argument. It's essentially the first words about what this case is about, and they're going to come out of your Honor's mouth. And I think that there's an unwritten importance that the jurors place on those words by the court at the outset of the trial. Under the Goss case, which is cited in our papers at 255 Georgia 678, that's a Supreme Court case from 1986 that's still good law. It specifically states, quote, trial courts are not required to read the indictment to the jury. Of course, the flip side of that is you are entitled to read it if you wish. One very important distinction between the charges that are presented to a trial jury versus a grand jury is the burden of proof. The jury in this case, if you read the indictment, will hear the charges that were brought against Mr. Duke based solely on whether there was probable cause. The jury's charge in this case is not going to be to find probable cause for his guilt, but guilt beyond a reasonable doubt. Typically, the court does not explain the difference in those burdens of proof, and the jury also is unaware, for the most part, that the grand jury proceeding is secret, and that those charges were brought outside the presence of the defendant or his counsel, and there was no opportunity for the defendant to cross-examine the witnesses that were presented at the grand jury. It's essentially uncross-examined testimony and evidence, and so the jury hears none of that. And prejudice to Mr. Duke in allowing the indictment to be read from the outset of the trial sets the entire frame for the jury's view of the evidence, view of the case, and it essentially gives the state the opening falvo, if you will, about what this case is about, and it gives importance to it because it's coming from Your Honor as opposed to the state. The state has the opportunity in their opening statement as part of its groundwork for what the case is going to be about to explain the indictment and what the charges are. And of course, Your Honor has discretion to deal with the charges and define the charges under the law for the jury at various points in the trial, including when the court charges the jury at the close of the evidence. There's The indictment, as the court routinely reads to the jury or states to the jury, is not evidence. We certainly think that that's appropriate but not sufficient to inform the jury that what they're hearing from the court in the indictment is not evidence, and I think it's difficult for the jury to cast that aside and then with an open mind hear opening statements. So we'd ask the court to exercise its discretion and not read the indictment.
Well, what about the court? Reading the indictment, what about the court telling the jury what charges are, why you're here? That you can come in your argument?
No, and I think, Your Honor, I think it's better. Certainly better to do that. It's the reading of the indictment, that the formality of it, that burns into the brains of the jurors before they hear 1 ounce of evidence in the case. And anyone who sat through this process, and Your Honor is well aware, the entire courtroom is waiting for the first words from Your Honor about what this case is about. And when the courtroom is silent and the jury is sworn and they've heard no evidence and you read the indictment, it's quiet, and everybody's attention immediately turns to the defendant and say, how in the world could he possibly have done that? And it's one thing for the state to say he did that because they're charged with bringing this case. It's another thing for the caller of balls and strikes to read the indictment verbatim right out of the get-go. So we'd ask Your Honor to just exercise your discretion under Goss and not read it.
Thank you.
Thank you, Judge.
Okay.
Your Honor, with regard to this motion, very specifically, as the court has just pointed out, when the indictment is what joins the issue in the case. It is part of the instructions that the jury has to understand to be able to make a decision of whether this person is guilty of that beyond a reasonable doubt. That's part of the court's instructions. It's part of the issue that was joined in this case to determine beyond a reasonable doubt whether Ryan Duke is guilty of the offenses that he's been charged with in this indictment. And so the indictment, it is an important part of the proceedings. In fact, this indictment is all over the national media already. It's been published everywhere already. And so the fact that this indictment is to be read, I don't see the harm in that. I want to point out that the 3 cases cited by the defense in their motion, Goss versus the state at 255 Georgia 678, it's a 1986 case, and I say that for this reason. That's not even the issue in that case. The issue in that case is not that the judge read the indictment prior to opening statements. The Goss case is that in the jury charge, after all of the evidence was in the jury's charge, it did not read the indictment in its entirety to the jury. That was the issue that was appealed, not that it was read before an indictment, read before the case began. What happened in that case, in the Goss case, is that the judge omitted a co-defendant's name when one person was on trial. And they said that was error because the court left off the co-defendant's name. And of course, the court comes back and says the trial court is not required to read the indictment. And they cite that Benefield case, and we'll talk about Benefield in a minute, which is the case that he cited. Well, that was not the issue. That was not error that the judge read the indictment. It was that the judge did not read the indictment in its entirety. The jury had the indictment with them. They found it was not error because they had it out with them. The co-defendant was cross-examined at the trial. The co-defendant was made an issue in the trial. Therefore, there was no error in that the court left off the co-defendant's name when he read the indictment in the jury instructions. The Benefield case that is cited by the Goss case at 148 Georgia Appeals 211, a 1978 case, it is also a jury instruction case that cited that the trial courts are not required to read the indictment. In the jury instructions, it was failure to read the entire indictment in the jury charge. Basically, the judge just told them he's charged with the offense of aggravated battery. And he said, you will have the indictment out with you, and he didn't read the aggravated battery count. And of course, they had then alleged error that the judge didn't read the entirety of the indictment. And the court said that because he had it out with you, and he later on instructed on the offenses of aggravated battery in his charge, giving the elements of the offense, then it was fine, and there was no harm that he didn't read a portion of the indictment, being the charge itself. Cates versus State at 271, Georgia Appeals 326, also cited in the defense motion, a 2005 case. Again, it's also a jury instruction, a jury charge case. None of these cases cited in their motion or stands for the proposition that the court cannot read it in its opening instructions to the jury, reading the indictment which forms the issue for which the person has been charged with. In Cates versus State, it was that the judge misquoted the trafficking in cocaine statute. He said purity of 10% or more of cocaine when it was supposed to say purity of at least 10% cocaine. So he just misspoke the words, and they said that the court's not required to read the indictment in its verbatim in its entirety for that charge, and therefore it's not error. Of course, we would ask the court to instruct, as it always does, on the indictment, giving the indictment, and deny this motion.
Any further, Mr. Murphy?
Just briefly, Judge, none of what the standards are changes the fact that you have the discretion to not read the indictment. Just ask you to not read it.
I'm trying to remember through the years. I believe that I typically do not read the indictment prior to trial. I think I have when I've done the charge. Years ago, before I was, for y'all's purposes, before I became a judge, I served on the jury when I was a practicing attorney too. And it was stunning to me in the jury room how closely the jurors watched the judge. You're right about it. And I remember telling our judges after I served, be careful, don't make that, because the jury's watching. I'm sensitive about that. And I'm sure I will, in some manner, inform the jury as to what I'm going to deny the motion, but I'm sensitive to those issues. Probably won't read the indictment. Probably will just tell the jury what the defendant is charged with in that regard. But I won't deny the motion. I don't think it's on solid legal ground, which is why I'm denying it. But I'm confident I won't read it prior to trial. That's just my normal practice. So I'll deny that. The next is how we're going to argue, closing argument, right? This is motion number 33. That's interesting that I understand your motion to say, Ms. Mercer, that in the federal system, it works different than
Yes.
you do it, huh?
Yes, Judge. And a lot of other states.
Pardon me,
A lot of other states as well.
I'll hear from you on that.
Thank you, Judge. Judge, our motion 33, is a motion for a full and fair closing argument. And what I mean by that is what our law allows currently is for the state to make an initial closing argument, the defense then argues, and then the state is allowed to make a final closing argument. And that statute changed several years ago, and there's been some question about whether or not the defendant is able to rebut what the state argues. Because how it happens in practice is that the state,
Well, they can't rebut.
right, we can't. And so what happens is the state can make their first
They
closing.
don't have to stay arguing.
Exactly, and sometimes they do argue. A lot of times, in a lot of the cases that are cited, the state did do it out of fairness. They did put all their arguments in their initial argument, and they did save their rebuttal for rebuttal. But they're not required to do that. And what we're asking for is them to be required to do that. And you have the discretion to do that. The law does not say that you can't do that or you shouldn't do that or it's reversible error. It says it's entirely up to your discretion.
Did it ever come up in the appellate books?
Warren versus State, it came up. And it's come up in the federal system a lot, and in other states. But what our statute says is that after the evidence is closed on both sides, the prosecuting attorney shall open and conclude the argument to the jury. The defendant shall be entitled to make a closing argument prior to the concluding argument of the prosecuting attorney. The federal rules, like I said, the federal rules of criminal practice say that the government argues, the defense argues, and the government rebuts. We would argue that our statute is similar to that. It doesn't say
Rebut.
It doesn't say rebut. It says conclude. It says concluding argument, that they conclude the argument to the jury, concluding argument. And again, you know, the state may get up here and say there's cases that say you don't have to do this. You don't have to do it. It's completely a fairness issue. It's completely an issue within your discretion. The advisory committee to the federal rules say that they drafted this rule because they believe it's fair and effective, and that the administration of justice is best served if the defendant knows the arguments actually made by the prosecution on behalf of the conviction before he is faced with the decision of what to reply. So essentially what we've got in Georgia is we've got a rule where the state can keep all of their arguments for the last word. And so we are forced to argue without knowing what the state's going to argue. And so they can counter everything that we've argued. So we get up and they get up and rebut us, but we never get to rebut them. So the statute, if it's construed where they have to put all of their primary arguments in their initial opening, and then they reserve their final rebuttal, their concluding argument, for a concluding rebuttal, then it's fair. The defendant is not asking for two closing arguments like the state gets. We understand our legislature, while we don't think that's fair, the legislature has said, because the state has the burden, that they get two closing arguments and we only get one. I understand that. But what we're asking for is that our closing argument be made after the state's made their closing argument, so that we have the opportunity to make our closing argument at the same time that we rebut the state's case. Because as it is now, the state gets to make their argument. Then they get to hear ours. Then they get to rebut what we say. All we get to do is get sandwiched in the middle and make our argument and guess what they're going to argue and try and anticipate what their arguments are so that we can argue around those. And what happens inevitably is they pose a lot of questions, and we're sitting there and thinking, you know, I wish I could tell the jury the answers to those questions. I wish I could explain that to the jury. And the law, if this is not granted, does not require the state to give us that heads up, essentially. This is similar. Let's just equate it to the motions today, okay? So we filed motions. The state's not required to respond. But we get to rebut what the state filed. So we put all of our arguments on paper so the state knows all of our arguments before we come in here. Then we make an initial argument. They're allowed to argue and rebuttal. We can't get up there and raise an entirely new argument in our final rebuttal. No, our argument in our rebuttal is to rebut what the state argues. That's because we have the burden in motions. And so that's what's appropriate. We're asking for that same procedural right to carry through to closing arguments. So just like what happens in motions. What we're asking for essentially evens the playing field to ensure a fair trial. It does not allow an unfair advantage that the state currently has. So the state, if this is not granted, the state has an unfair advantage. They're able to use that unfair advantage. They're able to rebut, and we are not. Daniels is the Georgia criminal trial practice book that's written by Judge Gouger. Judge Gouger in Atlanta wrote the book, and his section 23.2 on opening and concluding arguments, he writes that in Warren versus State, the Georgia Court of Appeals, while critical of the disadvantage a defendant faces when trying to conduct a closing argument without having first heard the basic position of the state, concluded nonetheless it was bound to follow Bradham. However, there is nothing in Bradham which suggests that the state has the right to waive its opening portion of final argument. It would certainly seem to be the better and fairer practice to require the state on a proper motion by the defense to make a full and fair opening and devote its concluding portion of final argument to rebuttal. This is the rule in federal court. That's what we're asking.
Well, couldn't the legislature very easily do that, though?
I believe the legislature has done that. Because, and there's no...
Just conclude.
Yes.
Rather than,
By saying concluding. I believe the legislature has. I'm sure that the state is going to argue that Bradham versus State says otherwise, but Bradham versus State does not. It doesn't say that the state has that right. It doesn't.
According to Jack Gouger.
According to Jack Gouger, and if you look at Bradham, Bradham has quite a bit. It's got the Court of Appeals case, and then it's got the Supreme Court case, and so I went back because it was the only case I could find on this. So I wanted to look at the history, just kind of see how, because sometimes we get this rule that's taken out, dicta out of a appellate opinion, and right, and where did it come from? So all of these arguments by the state always cites the Supreme Court rule. Well, so I went back and I looked at the Court of Appeals one that was overturned on certain grounds, not this ground, and they talk a lot about this. They talk a lot more about, how this came about, essentially. And I think I sort of parsed it out in my motion. In Bradham, the Georgia Supreme Court affirmed the Court of Appeals opinion that held that a trial court did not abuse its discretion when it allowed the state to waive its opening portion of its closing argument and reserve its final argument. A finding that the court did not abuse its discretion is not a finding that that's what the legislature said. It is a finding that it was not abuse of discretion under a harmless error standard. Not being an abuse of discretion is not the same as saying that is what the law says.
In your position, Bradham stands for the proposition that I can do exactly what you're asking me to do.
Exactly, Judge. And it stands for the proposition that if you don't, you will probably be protected on appeal.
Right.
It does stand for that, but it doesn't make that the law. It says that your ruling is going to be reviewed for an abuse of discretion under a harmless error standard. It doesn't say that that's what the law says or that that's what the statute says. Contrary to the arguments that we hear on this, Bradham does not say that. It doesn't say that you can't give this or that the legislature did not mean this when they said concluding argument. It doesn't say that. The decision from the Court of Appeals is the decision that somehow began this belief that the state has a right to waive its initial closing and that the defendant does not have a right to make a closing argument after fully knowing what the state's argument was. But that's not what Bradham found. It found it was not an abuse of discretion, and in that case, in the Bradham case, based on the Bradham facts, allowing the state to waive its argument, in that case, did not have error because the state argued everything in their opening statement.
That's the state you jeopardized Bradham. Did you find any?
I found the Supreme Court one. I found the Supreme Court case, the Bradham. Yes.
Another case?
No, I found a lot of Court of Appeals cases that cited Bradham, and they cite Bradham for the proposition that the state doesn't have a right to waive, that there's no right to waive. So all of the subsequent opinions say that the state does not have a right to waive this.
It's discretionary.
It's discretionary. Yes, Judge. In that case, though, in Bradham, the reason there was no error and it wasn't an abuse of discretion is because the state complied anyway. Even though the court didn't order that they have to make the first argument and put all their points in the first argument, in their rebuttal, they did just rebut. They didn't bring up new arguments in the rebuttal. So that was a really important holding in Bradham because, and the court specifically found the state may have argued new facts, but there's no showing of the record in this case where there was anything other than rebuttal. Also, Bradham, I think this is important to note, the Court of Appeals said that it wasn't objected to, so it wasn't preserved for review anyway. So that always affects the appellate opinion in a case, whether or not it was preserved. So it was moot anyway. But somehow now Bradham is the rule, even though they said that this wasn't even preserved for appellate review. It's been cited from numerous Court of Appeals cases to say, to knock down the argument that we're making. And that's not what Bradham does. Bradham doesn't say that. There are numerous federal cases that say this is the fair thing to do. Numerous other court cases that say that. And so we would ask that this does not create, by granting our motion, you are not giving the state any unfair advantage. You're not giving us any unfair advantage. What you're doing is you're leveling the playing field. You're ensuring a fair trial. Currently, what the state wants in opposition to this motion is an unfair advantage. It is an unfair advantage to deny the defendant the right and the power to rebut the state's arguments and closing argument. That's an unfair advantage. And they're arguing that the law applies that, but you have the discretion to say, I'm not going to let the state have that unfair advantage. I'm going to level the playing field. And that's what we would ask for you to do. Thank you, Judge.
Okay. Mr. Green?
May I approach?
Your Honor, the Criminal Justice Act of 2005 is what changed the statute, which is OCGA 17871. The legislative intent behind the statute was just what is here, is that the state has the burden of proof and we have the right to open and close our argument. That was the legislative intent behind the passing of that statute. And the statute says, after the evidence is closed on both sides, the prosecuting attorney shall open and conclude to the jury. The defendant shall be entitled to make a closing argument prior to the argument of the prosecuting attorney. So, again, the statute does change. So Bradham changes as well. However, the spirit of Bradham and the decision of Bradham goes on. And I want to direct your attention, when I shepherdized Bradham, I got a lot of cases that I'll cite for your honor, ones that deal with this federal Rule 29.1 as well as these federal court cases that were mentioned. And this has already been decided contrary to their argument in the Supreme Court of Georgia. And so the issue has really already been decided against what they propose. The one that I would cite for you specifically is Lewis versus the state. Lewis versus the state is at 2. Actually, that's the Court of Appeals one. But let's see, the Lewis versus state. Are they both? Let me make sure I got my notes written down correctly. 283 Georgia 191 is. In this case, this is citing, it cites Bradham in that federal rule. I direct your honor to page 7 of 9. It's paragraph 3. At trial, the prosecuting attorney waived his initial closing argument and elected to make a full presentation following the defense's closing argument. On appeal, Lewis argues that OCGA 17871 prohibits the state from waiving its initial closing argument, and the trial court erred in permitting the prosecuting attorney to do so. OCGA 17871, as amended in 2005 and applicable to this appeal, reads as follows. And then it sets out the statute. The amendment, and I'll just go down to the next sentence, the amendment eliminated the last sentence of the previous statute, which read, if the defendant introduces no evidence, his counsel shall open and conclude the argument to the jury after the evidence on the part of the state is closed. Lewis points out that the language of the amended statute bears a close resemblance to an earlier version of the Federal Rule of Criminal Procedure 29.1. in which the words, the prosecution shall open, have been interpreted as a mandatory directive requiring substantive initial closing by the prosecution, citing 2 federal court cases. Lewis adds that prior to the enactment of the statute as amended, a defendant was entitled to open and conclude argument if he presented no evidence, that the amendment to the statute eliminated that right and gives the state a decided advantage, and that we were to interpret the amended statute as merely directory, we would add up to the advantage and impinge upon a defendant's ability to fully and fairly argue his case. This court has held that for the purposes of statutory construction, the word shall is to be generally construed as mandatory directive. However, the word shall need not always be construed in that fashion. And then it cites a few cases. It goes down, thus prior to the amendment in 2005, OCGA 17871, gave the prosecutor the right to open and conclude unless the defendant decided not to present his evidence, in which the case the defendant gained the right to reopen and conclude. The 2005 amendment took away the right of the defendant to open and conclude, but it did nothing to alter the prosecution's right with respect to closing argument. And it cites Warren versus the state. Warren versus the state is the Court of Appeals case cited earlier, which also addresses the federal rule as well as the federal cases. Warren was decided against their position as well. The trial court did not abuse its discretion in allowing the state to make a non-substantive initial closing argument in the defendant's criminal matter and reserved its full presentation for its conclusion, because the state has the burden of the proof and the defense had to respond to an argument that it had not heard and was not allowed to do so. In Warren versus state, the language at 281 Georgia Appeals 490, it's page 5 of 8 of this opinion. At the conclusion of the charge conference and outside the presence of the jury, defense counsel asked the court to require the state to present a full initial closing on the ground that the statute required it to do so. The trial court responded that it was not going to tell them how to do their closing argument. That's up to them. Defense counsel then added that the state should be required to make a full initial closing so as to prevent the defense from being ambushed. And finally, if you'll go to page 7 of 8, it refers to the Bradham decision. Paragraph beginning, in Bradham versus state, however, the Supreme Court decided 25 years ago, the Supreme Court of Georgia held that a trial court does not abuse its discretion when it allows the state not only to waive its initial closing argument, but also make a full presentation regarding the legal facts and facets of the case, the jury following the final argument of the adverse party. Bradham rationalized this holding by citing case law and different questions of whether the defendant may reserve its opening statement. However, the decision nonetheless authorizes the state not only to waive its initial closing, but also to reserve its full presentation for the conclusion, even though the state has the burden of proof and the defendant will be required to respond to an argument he has not heard. And so, of course, given this binding precedent, we hold the trial court did not abuse its discretion when it allowed the state to make a non-substantive initial closing argument and to reserve its full presentation for its conclusion.
They think it's binding precedent, right?
Sir?
This is given this binding precedent.
Right. And of course, their position is that Bradham was incorrectly ruled and incorrectly cited for that proposition. But nevertheless, the Supreme Court in Lewis has gone on to affirm Warren and cites Warren in its Lewis decision. There are other cases in the Supreme Court in Petty versus the state that you have before you, 283 Georgia, 268, a 2008 case, that in summation, that the statute did not require the state to give an initial closing argument. The trial court permitted the state to waive this argument. It also cites Bradham. The Petty case does. There's also English versus state in the Georgia Court of Appeals at 282, 552, a 2006 case. The state was permitted to waive its opening argument until defense counsel had argued. The defendant objected. The state was not required to present a full and fair initial closing argument. English court cites the Warren case that we've already talked about. And then there's Lewis versus state that you have before you again. The state is allowed to waive it, waive the opening argument, and entitled to reserve its closing argument until after the defendant departed. And that was a felony murder case involving voluntary manslaughter and the same types of charges we have in this case. So based upon those cases, this has already been decided. We ask that the court deny this motion. The state is entitled to a fair trial as well in that regard, and we are entitled to view that to present the burden as the legislature intended. Thank you.
Judge, the state's cases said exactly what I said that they would say, that it's discretionary and that you would not abuse your discretion deciding one way or another. That's what all those cases say, all of the cases that the state just cited. What we're asking is for them to have to reserve their final argument for rebuttal. What we have here is a motions hearing where we are able to rebut what the state argues. I did not know coming in here today why the state was objecting to half of these other than the fact that they wanted the advantage that it presented. Let's take this motion, for example. Of course they want this advantage. It's a huge advantage or else they wouldn't be fighting so hard against it. They want the ability to bring up issues that we cannot rebut. So how this motion is fair is we file a written motion, we walk in here and we have no clue what the state's going to argue because they're not required to file any motion. They make their argument and then we are able to rebut. What their version of the statute does is it does not allow us to answer any of their arguments in rebuttal. What would be fair and what would even the playing field is for the state to have to advance all of their arguments in their initial closing. We advance everything in our closing, and then they are able to rebut anything that we said. That way we both have a right to rebut. Any other holding takes away our right of rebuttal. And they are relying, and the courts have been relying on an abuse of discretion under Bradham for years. Yes, you don't have to do this. There is no law that says you do, but there's also no law that says the legislature intended for the defense to not have the right to rebut. There's no law that says that. There is nowhere that says we do not have a right to rebut. This is the only place in criminal law that we do not have a right to rebut, or that the state is the only one that has a right to rebut. Every other opportunity, we both get to make our arguments. This is the only one. And it is an extremely unfair advantage. And so the question for you is whether or not, first of all, is it fair? Is it fair for them to have the right to rebut and us not? Isn't it an advantage? I think it's obvious that it is an advantage, or else the state would consent to it. Do you want to exercise your discretion and allow us the same right that the state has to rebut any of their arguments? They still get the final word. They have the burden of proof. They still get the final word. That's not going to change. All this is going to do is it's going to require them to advance their arguments before we have to conclude, so that we can adequately defend against those. And so that's what we're asking, is for you to exercise that discretion and grant this even playing field that we're asking for. Thank you.
Submitted a lot of reading material for me. Now that gets us through the motions we set for here today. I want us to let's take a lunch break. Come back at 1:15. I want us to talk about this Dean motion. Is there anything else?
I'm sorry, did you say the venue motion?
Right.
Yes.
You want to talk about any Dean motion this afternoon? Anything else we need to discuss?
Other than just scheduling, Judge, I know we discussed that some on the phone.
We need to talk about what we're going to try in this case as well. Okay, we'll recess at 1:15.
Thank you.